Do you want me to take a picture of the outgoing email
No,
and send it around?
I have found in the situation, and as far as where and on dealing with it, I found thing from the, just a minute. Okay, one of the things that we need, and as far as that you can put in, as far as the um, can put in the issues regarding the attorney's fees matters, is that I note that I didn't get, I mean, one of the problems, and I, acknowledge, I try to get everything in of the emails of poured into Chris. And that is, I will acknowledge in the situation that I didn't get that in, and you did submit the answer on the 14th. What we need to do in the circumstances is to recognize that there are 3 different things that happened, and I'll acknowledge that. And the most important thing is going forward today. But as far as in dealing with the, there's a chain of different things going on. I granted the motion, and as far as in dealing with, you can see the July 6th email that based on what I understood anyway, and to be the record that I had at the time of on July 6th. Now, to the extent for the issues regarding attorney's fees or other things that you want to in your response to point out in dealing with that, where, if any place that is an error regarding the circumstances, then you are welcome to, regarding laying out the matters and as far as when things were submitted. But the fact is that I made the order at that time. And so when there was a issue regarding the compliance with the order, the issue regarding granting the order was no longer there. So I was dealing with my understanding of the facts at the time that I made the ruling previously. So as to why in the manner, since I understood the motion issue to be dead, because I had already granted the motion, that you're arguing that she didn't consult constituency was moot. It had been dealt with already. But now we are dealing with, and so again, if you want to argue regarding the motion or the any attorney's fees award situation, then the extent to which I've tried to lay out on both of them what I understood the fact situation to be, to indicate that what you submitted prior to the 28th, in my understanding, did not address what I was looking for. And this is dealing with, in the matter. And so that's why I did what I did. But the situation now, we're dealing with the circumstance regarding, okay, I can't go, and this is in the matter, I can't go back to the 6th or the 28th. We're dealing with this in situation we're dealing with, and I'm not at this point in the matter, dealing with the extent of the attorney fees that should be ordered in the matter, to the extent to which that for your response, you want to lay out the situation and look at the matter and argue based upon, again, it is dealing with whether or not for the attorney's fees issue, that dealing with as to whether they are warranted based on unnecessary time or expense being incurred by the complainant and his attorney in order to get to the point of the hearing. That's the issue for that. That's not what we're dealing with this afternoon in the situation. Please, as far as to lay that out regarding the circumstances, and again, to the extent to which that you deal with the issues that I'm trying to deal with rather than something else, I will find your submittal much more persuasive if it actually is dealing with what I'm trying to deal with. But I'm looking at those time frames and the circumstances and whether or not there was unnecessary costs or time consumed, including the fact of the cancellation of the hearing, basically, today, as the matter as to how that occurred and whether there should be costs assessed as a result. But this afternoon, what I'm dealing with is, okay, what do we need to deal with in order to correct the situation, however we got there, whatever the situation is. I'm not dealing with the attorney's fees portion. I am separating the two things into basically two components. And that is one, how do we go forward? And second, should there be attorney's fees assessed because of the delays? But I'm not dealing with that second one right now. Okay, so the first in the manner, and my understanding, and we are dealing, as far as the first thing, as I understand it, a combination of the two. I made a request regarding and dealing with the answer, and as far as the situation that I'm trying to get a statement as to what the claimed non-discriminatory reasons are, and also to note that my request for an answer is particularly it is connected to or very similar to interrogatories 3 and 5 regarding the situation. And just to check, was there a supplement to the interrogatories 3 and 5 since the time when, Ms. Salata, that you replied to the submitted your declaration?
Yes, but it was still not detailed.
Okay, and the matters, and just saying, and I would understand as well, there's some, discussion that certainly there are more details in the amended answer. And I think in the matter that since that is not apparently, that there are details regarding, what it doesn't say, and I just sort of note, when you have in the answer references to things which clearly cannot be known by the person involved at the time of the decision made, then it raises questions in my mind as to, and I think they're reasonable, as to what was the basis for the decision, since it obviously can't be the performance of Mr. Baluk's replacement. That obviously how he would perform or she would perform in the next 2 years obviously cannot be a decision to be a factor into what occurred. So I just would note in the matter that neither one of in response and dealing with the circumstances, that the sort of the start of a variety of things, because the combination of response to in the order that I will prepare up dealing with the situation in order to know and to deal with the situation, we have two different decisions. And my understanding is that there's a reference in the interrogatory to the question being asked, explain in detail the person's involved role or involvement in the decision to transfer the complainant. So my understanding is that that is clearly not dealing with sufficient in the combination. And my understanding is that this would involve a timeline as to when certain issues were done and what was considered prior to the discharge. So that would involve on this date, and these things were raised, and these things were considered, and these were the communications involved. And my understanding is that that is in order to deal with the matter, and we're talking about prior to a first decision and what occurred between those two decisions, that I need a timeline, a consultant, and the role of the parties dealing with, and to whether or not the question of the continued existence of the issue regarding the elimination of the position, when that was first raised and what that discussion was. So is that clear, Mr. Brady? It's a combination of my request and the answer to the interrogatories.
It's what your request is not supported in the interrogatories. The interrogatory asks for the person's role or involvement in the decision to transfer. That's outlined in the interrogatory response. You're asking for a timeline of events, of which the timeline of events is adequately outlined in the documents that are provided.
Where is it outlined in the documents provided?
It's in the complaint. It goes through the
not the decisions.
It goes in the chronological order of what his employment was.
No, that's not what I'm not talking about that. I'm talking about the decisions. I'm talking about a chronological thing regarding the decisions and not the actions of the result. So in dealing with the matter that and I just would note in the situation that in the situation that if that how I will work in the situation regarding the restriction and other things is that if a discussion, a consideration is not mentioned in this response to the interrogatories and or how you want to do it, the answer, then I will view that since you didn't mention it, that you can't have testimony about it. My understanding is that you have raised past issues regarding consumer complaints, and the consumer complaints and the sales, but there is no indication as to when they were, as to where they came in a discussion or when, of what the course of events that resulted in the decisions. That in dealing with and you'll have, that my understanding is that the explain in detail is not, we make personnel decisions for internationalists to promote performance and further company objectives. That is not an explanation in detail. I am asking for saying that in order to comply with interrogatory 3 and 5, you need to explain in detail, and I'm telling you what the explain in detail means. That is, when was it raised, when it become a concern, and how did those concerns come up to be a deal of the matter? And please don't reference anything that happened after the decision was made, because obviously they didn't know about it at the time. And how long do you need to, dealing with the matter? I'll give in the situation in the matter 20, 30 days. How long do you need to complete this discovery, Mr. Brady?
As I indicated in my objection, these are an ongoing dialogue that's more appropriate for a deposition. The depositions.
I'm not-
The deposition.
I am telling you what dealing with the situation, what you need to do for us to, for me to reschedule the hearing. We need to get dealing with as far as this, the question, so I can figure out to the extent to which what additional things, and so that there's been an opportunity, because these kind of vague responses do not reasonably allow a complaints attorney in order to check or determine or to have a chance to prove or establish pretext. They would make personnel decisions for international as to promote performance and further company objectives. That is just way, 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 way too vague. That doesn't tell us anything that can be checked. And the idea is that, yes, you have a right to articulate the claimed reason, but they need to be with specificity enough that they allow for attempts at proving pretext. So, and I need a timeline of when the discussion with an understanding is that when your clients testify, if you don't raise or talk about an event happening, that if it's not raised or identified in this response, it'll be excluded. You understand?
I understand, and if the court would respectfully allow me to finish, we still have a deposition of someone, and we don't have the deposition transcripts from the last one. So if we're going to schedule the deposition for Tony Prestula, we would need to do that, and those would need to be incorporated in my response.
Well,
So
these things regarding this response needs to be, the normal order on the situation is that you get written discovery prior to the depositions. No, that this in the matter is that you do what investigation you need to do to answer this, and then the deposition, to the extent to which we need a supplement to the deposition, will be after you provided this information, because Ms. Salata cannot be reasonably expected to ask questions in the deposition without you having articulated what you're claiming the matter. How can there be questioning or asking questions regarding the, evaluating and see what the foundation and other things about it if you haven't articulated yet? So no, the deposition will be after this, not before. Okay.
it's not a supplemental deposition, Your Honor. It's one that hasn't taken place yet.
Well, right now, that we are dealing with two potential supplemental depositions, and we're talking about a potential deposition. So dealing with that, we will see, and I haven't decided that there be one or not. But in dealing with the matter that these things, and I will give, just to make sure that in the matter that you have 30, I'll make it 20 days. So in dealing with the situation, and these are not, again, these are dealing with what happened and who involved in stuff, because as to these discussions in the matter, that if they are not identified as a action, communication, if something doesn't raise it, or the looking at files or whatever they happened regarding these people coming to these decisions, that especially since that we are dealing with a important issue that requires that it's reasonable to understand, is what was decided or known prior to June 6th, so that we can figure out as to whether I will have to make a decision in the findings of fact, as to whether at the time that the motion was made, that the decision makers were planning to eliminate the position to which he was demoted or not. I'll have to figure out and decide in the matter, were these events that has resulted in what the respondent is claiming is the elimination of the position, were these things which were unknown and that occurred between those 3 weeks, or basically was he moved to a position which they knew was going to be eliminated 3 weeks later? I will have to make a decision about that, so thus that there will need to be that a situation as to whether or not that those identifying when the decisions were made and what was considered and who talked are part of this timeline. And my understanding that this is a combination of an answer to interrogatories 3 and 5 and and as well as the clarification of the articulation of legitimate non-discriminatory reason. So in dealing with in that, and as far as I need to in the matter to indicate, because part of the thing is I want to, if we're going into the hearing with exclusions, I want to be much more clear as to what I will exclude. And so in this manner that what I'm saying is that if it is not, if you don't mention a conversation, if you don't remember a conversation or a consideration or, a receiving information in these dates, that I will exclude testimony about them at the hearing if you don't identify that, that, well, we got this report and that includes when reports was received. You're saying that at the beginning of the month or at the 14th of the month that some reports are received and this had to do with the situation, then we need to, the timeline needs to be, if not mentioned specifically what's going on, then I'll exclude. If it is not articulated or dealing with somewhere else. Okay, so and this needs to be within 20 days.
Can we do it September 10th? That'd be 24 days, I believe.
Yes. Yeah. Okay, so, then as to do with the other, the other issues that you raised in the claim, because we're dealing with this point with the enforcement of my order and dealing with the situation. We're not dealing with the order and whether there was adequate, we're not dealing with order, we're dealing with the enforcement of it. Mr. Lotto, what other things are you viewing that included in the things that were discovery that you view as necessary to for your case that have not been provided to date?
So I'm sorry, it took us all the way right up until 1:30 to be able to complete that. I did email a letter to both of you that outlines that. It has, you've already identified part of that being interrogatories 3 and 5. 6 and 7 are related to comparators.
And let me just hold a second.
Sure.
Let me just see. Okay, and dealing with that, is there some, Mr. Brady, regarding 6 or 7, are you claiming that there was some, let me just, what were the questions on those? I'm trying to find it among these. Okay, now I got the right document, I think. information about other employees who were terminated. What was the questions? Because I'm sure that is